Hi, my name is Mark Stipic. I'm the work cover guy. Thank you very much for tuning in. Today I'm answering the question, how can injured workers appeal decisions that are made on their work cover claims? Now, there's a number of different ways, and sometimes potentially the first way, there's the informal way, which is potentially to call up your case manager and say, I noticed that my payments are due to come to an end on this particular date, or maybe my physiotherapy has been approved up to a particular date. There's reason that I'm going to need to continue it on beyond that date. What do I need to do? And they might actually give you some guidance on, well, look, yeah, we do need a new referral. If you send us a referral, we can approve another 15 sessions, something like that. So quite often there is an informal path for workers to follow, depending on how serious the entitlement is that they're claiming for. In the event that there's actually been a termination notice issued, like a letter that's sent out saying that we are cutting off your payments or cutting off your treatment on this particular date, those letters contain the dispute, the appeal rights for an injured worker. The first one is to request an internal review. What happens during an internal review is the case manager would need to refer it to someone senior, like a team leader within the insurer, who then needs to check that it is a valid decision. Very rarely does an internal review result in an overturning of the decision, primarily because the insurer is unlikely to go back on the decision. They're more just there to make sure that we filled out the correct letter, that there was evidence to make the decision, and that the case manager did the right thing. So it's really only going to pick up some sort of flaw in the process. Failing an internal review, and look, you don't have to do the internal review. An injured worker can skip through to step 2, which is basically to lodge an appeal with the Accident Compensation Conciliation Service. And they will go through a bit more formalized process, and it's much more likely to result in some sort of outcome. Not always the outcome the worker wants, but it's more likely that once a conciliation process has started, you're going to get a more clear-cut indication of how or if the decision is going to change. Generally, if the decision can't be resolved at conciliation, the worker could be issued with a genuine dispute certificate. What that means is the worker has the right to seek legal advice, because you can't go to court about a matter until you've gone through conciliation. Now, from there, just because a worker's gotten a genuine dispute, it doesn't guarantee that it will go on to a court matter, because really, the worker needs to seek legal representation. So if they haven't got a very strong case, if the decision that was made really is without a doubt the right decision, look, the no-win, no-fee lawyers are going to do their due diligence, and if they can't win the case, they're not going to represent the worker. And it's pretty unlikely, I've almost never seen it, that a worker would volunteer to pay out of their own pocket to get a lawyer involved because they feel so passionately about disputing the decision. Not to say it wouldn't happen, just to say that I haven't seen that happen. So it really depends on the strength of the case. I guess the lawyers generally are pretty good at weighing up how likely are we to win this case on behalf of the worker. But they're not allowed to get into that territory until the worker's been issued with a genuine dispute from conciliation. So those are the primary ways that workers can dispute the decisions that are made on their work cover claims. I hope this has been helpful for you. Thank you very much for tuning in, and please subscribe to my YouTube channel. If you've got a question for me, just leave it in the comments on YouTube.